Morning, Your Honors.
Good morning.
I'm Lawrence Klepetko from Sarasota, Florida. I represent the appellants in this case. We're meeting today on the anniversary of D-Day. I hope we all have fond reflections of our rights that were preserved for us by the people who participated in that momentous event. Could I ask for an indication of 5 minutes of time?
Sure.
For rebuttal. By way of introduction, let me go over the points I expect to cover in argument today. First would be the primacy, as I would view it, of the right to plead under the Florida Rules of Civil Procedure, particularly in this case, be a balancing of the rights to plead under Rule 1.190 of the procedural rules as opposed to a plaintiff's right in this case to dismiss its cause of action under Rule 1.420 of the Rules of Civil Procedure. Of course, here to discuss principally the distinction of the Stockman case's facts in this particular case. I'd like to go through the concepts of everybody is presumed to know the law. We have a couple of presumptions possibly under this old saying that may be relevant to this case. We have something of a chicken before the egg situation on the facts of this case. What comes first? You're aware of the right to make a pleading regarding fees and costs.
Counsel, if you're claiming entitlement to fees and costs, don't you have to put that in your response of pleading? Isn't the case law well established in that respect? And my follow-up question would be: are you asking this court to retreat from that rule of law?
No, sir. I'm asking you to enforce it because the distinction in this case from Stockman is a clear effort to seek amendment of the pleadings. That there was no such thing done under the facts of Stockman. That is the big distinction in this case. An effort to amend the pleadings to claim a right to fees and costs.
At what point in time did any attorney file a notice of appearance before a dismissal of this cause of action?
Before the notice of dismissal?
Yes. Before the notice of dismissal, did your client's attorney file even just a notice of appearance?
No, sir. And let me clarify that.
Does the record tell us whether they had an attorney at the time this case was dismissed?
I believe the record showed clearly that I prepared documents in my client's behalf, and they...
Did you appear?
Not prior to the ruling.
Would the record tell us that at the time this case was dismissed, there was no attorney appearing in this case on behalf of your client?
That would be accurate.
Okay. So if there is no attorney in the case, how does one get attorney fees?
Through a service that was provided to the defendants in this case other than representation and appearance as counsel of record in the case. There was extensive work.
That's not the law. I mean, your service won the case for your clients, I assume, but you can't not put yourself on the hook legally and prepare documents. Your clients are pro se's under that, and what Judge Casanova is saying is because they're pro se's, they can't get fees, and as Judge Black says, if fees aren't pled, they can't get fees. So it seems like a pretty strong case as to why fees weren't granted to your clients.
I think the record, Judge, would be much more clearly. My clients were never granted the right to seek attorney's fees through an amended pleading. There was never a ruling as to whether...
But Judge Casanova asked the dispositive question. He said, before the notice of dismissal, was there any attorney of record for your clients? And you candidly said, no, there wasn't. So you can't amend to inject an attorney during a period of time when there was no attorney.
And my response would be, I think you're making a fundamental mistake regarding an entitlement to fees to be restricted only to fees earned as counsel of record, as opposed to providing a service in the preparation of documents and in the counseling without appearing as counsel of record. I think there's a fundamental error being made under those circumstances.
But there's no case in Florida where someone prepared documents, an attorney prepared documents but didn't file an appearance and got fees, is there?
I would agree, Your Honor, that among other distinctions that this case would present is whether or not there would be a fee entitlement under these circumstances. I thought the principal distinction in this case would be the facts of Stockman, but since you bring that up, that would be an interesting additional point. Whether an entitlement to attorney's fees relates to something other than appearance as counsel of record. Everybody's presumed to know the law. Presumably, defendants would be presumed to know the law of the Stockman case, that if you don't have an indication of fees prior to a plaintiff's dismissal of the case, that the Stockman case says you aren't entitled to fees. However, every plaintiff, and let's make this clear since this is mortgage foreclosure, every plaintiff in mortgage foreclosure goes forward with an awareness that there is statutory entitlement to attorney's fees and costs under particularly the fee switching statute pertaining to attorney's fees. So the plaintiff is aware of that. Let me switch to the primacy of the right to plead. I think you all would be familiar with the liberality under the Florida Rules of Civil Procedure for amendment of pleadings. I think you're aware as well of the strong public policy in Florida to allow pleadings. And that is the big distinction in this case from Stockman. The effort made to amend pleadings specifically for attorney's fees and costs. And this case, of course, has court discretion in the trial court regarding an amendment of pleadings. That discretion is limited in the jurisprudence by the strong public policy of Florida to allow amendments of pleadings.
But you see, the problem is the rule of amending pleadings says that liberality should be freely granted, but it goes on to say, however, that liberality diminishes as the case progresses. This case had progressed to finality, and further, we haven't even touched upon the fact that the motions and documents filed weren't even signed by you or your clients.
They're signed on behalf of my client, Your Honor. I mean, is that a limiting factor under the circumstances? And maybe, well, maybe that will be addressed by the court further. If I may read from a decision of this court in Dousman versus Hillsborough Area Regional Transit, 898 Southern 2nd 213. I'll omit the citations. A party may, with leave of court, amend a pleading at or even after a hearing and ruling on a motion for summary judgment. According to Florida Rule of Civil Procedure 1.190A, leave of court to amend pleadings shall be given freely when justice so requires. Leave to amend should be freely given, the more so when the amendment is based on the same conduct, transaction, or occurrence upon which the original claim was brought. The decision whether to allow the amendment of a pleading is within the trial court's discretion. However, the trial court's discretion should be exercised in accordance with the public policy of this state to freely allow amendments so that cases may be resolved on their merits. Now, I would suggest that this is the effective standard of review for the court in this case, the public policy of Florida to freely allow amendments to the pleadings. I'm particularly relying on Rule 1.190E of the Florida Rules of Civil Procedure. Let me go through that briefly, if I may. Amendments generally, at any time in furtherance of justice upon such terms as may be just, the court may permit any process, proceeding, pleading, or record to be amended or material supplemental matter to be set forth in an amended or supplemental pleading. At every stage of the action, the court must disregard any error or defect in the proceedings which does not affect the substantial rights of the parties. This again is the principal distinction in this case as opposed to Stockman, the right to plead. Now, of course, there would be the argument that I would anticipate that when the plaintiff dismissed its case, the case is over. Well, that's only under the circumstance that you read Rule 1.420 by itself without reference to the other rule regarding amendment of pleadings. And I would suggest to you that this is particularly difficult under the circumstances because at the very moment that the dismissal became effective, the cause of action to amend for amendment of the pleadings had then accrued. Prior to then, that was a prospective cause of action subject to a condition precedent that in this case, the defendants were the prevailing parties. So, as to a procedural matter for handling by the court, what are defendants to do? Are they to bring this cause of action for fees and costs in a subsequent lawsuit? Should it be handled in the same lawsuit as was requested in this case? Or are the defendants simply without any remedy to seek fees and costs? I hope the court will address these particular procedural matters because, again, there is the primacy of pleading. What is the difficulty with Stockman? There were no pleadings. Stockman went forward with just the presumption that the plaintiff was entitled to take its action without any prior indication of interest in costs and fees from the defendant. Well, if you allow the defendants to plead a right to fees and costs, then you can also allow the plaintiff to bring whatever responsive pleading may be appropriate at that point, whether or not that plaintiff has been prejudiced under the circumstances. Then the issues are before the court in proper pleadings, which I suggest is what should happen in this case. It should be...
You've got 5 minutes remaining.
I will talk to you again in rebuttal time. Thank you.
Very good. You're welcome.
May it please the court. My name is Richard Swank. I'm an attorney with Baker Donaldson in Orlando, and we represent the defendant FLE, or I'm sorry, the plaintiff FLE, HSBC Bank in this case. I believe the court is correct. I think the Stockman v. Downs in that line of cases is dispositive here. There were multiple pro se motions to dismiss filed, then there was an answer filed, and in none of those documents were there fees sought.
Well, and pro se's can't seek fees anyway.
Well, entitlement to fees down the road, perhaps, but the fact that they were on notice by virtue of the clause in the mortgage, which was cited by the lender, stating that they are entitled to fees if such fees came about. The court never reached the question that your honors have raised with respect to what fees were there, because there was no appearance by an attorney in this case. In fact, I would point out to the court that I think prior to the notice of appeal, there was no appearance by an attorney ever. There was this endorsement, which frankly I've never seen before in a case. On May 12th, volume 2, page 291 and 292 of the record, was the last filing by the defendants in this case, and that was the motion for leave to amend. That was executed by the defendants themselves with the endorsement. So there was no actual appearance by an attorney until the appeal in this case. So I would maintain that the Stockman v. Downs line of cases is dispositive in this case. There were no attorney's fees sought. The court did not abuse its discretion in failing to permit the amendment of the pleading, which I would also point out did not include an answer, simply included counterclaims. So there's a possibility that had the court reopened the case and allowed that filing to be that pleading to be filed, there may have been a waiver of any affirmative defenses that were asserted in the answer. With respect to the prevailing party, I believe there is case law out there that says that if a plaintiff files a voluntary dismissal without prejudice, that the defendant could indeed seek fees if that is warranted, but that wasn't done in this case, and I think Stockman is dispositive. So I'll use the rest of my time to answer the court's questions.
Thank you.
Thank you, Your Honors. You're welcome.
Mr. Fleckville?
Clarify the facts. My memory of the case, Your Honors, is that the case never reached the point at which the defendants filed an answer. They did file defensive motions, and those motions were never scheduled for hearing. So to the extent that this case went forward without an answer, it was nonetheless vigorously defended on behalf of the defendants. With reference to the Stockman case, I argue to you that that is factually distinguishable in this case by the effort to seek an amendment to the pleadings, and this was very diligently done after the plaintiff dismissed its own lawsuit. First, a motion to seek fees, then a subsequent effort very promptly following to seek amendment of pleadings so as to assert, as indicated by the trial judge, the recognition of proper pleadings before the court regarding fees and costs. Now, I think the court's question about whether or not fees are attributable to attorney's services on other than counsel of record is a legitimate question. However, I would also question whether that is relevant today, since we never got to the point of even having any pleading recognized by the trial court regarding fees and costs. And again, as to the plaintiff's right to dismiss its own cause of action, I suggest that it's error to focus on that by itself without reference to the rule for amendment of pleadings, the liberality expressed within those rules to allow such pleadings, and the public policy of our state to allow these pleadings. Again, the pleading process allows issues to get out and before the court so that they can be adjudged accordingly. The trial court can see what is the relief sought by the first party, and the second party would have an opportunity to file a responsive pleading. Then the matter can go forward with proper pleadings before the court. Again, that was never part of Stockman. The key for Stockman is just presume with no pleading that the plaintiff is going to be prejudiced with a claim for fees and costs without a prior pleading or an expectation of receiving such fees and costs.
And your time is up.
Thank you, Your Honor.
You're welcome. Thank you both.